yes, you know the music, you know it's Thursday, and you know it's time now for the Legal Beat with Newberger and Partners. Plain talk about legal, liberty, and social justice issues that impact all Canadians. What we need to know and want to talk about today, of course, in studio, Joseph Newberger. Good to see you, sir.
Nice to see you too. Hi.
So what is going on with Ezra Levant?
He seems to attract trouble wherever he is. You know, he's outspoken. But, you know, it's an interesting issue because there has been a change in the code of conduct and a lot of talk about ethics and civility with lawyers. And the law societies across Canada have always been very, very good about having high standards. But this is interesting in the sense that he hasn't practiced law in, I think, over 13 years. And his column or his piece was with respect to the Alberta Human Rights Commission handling a particular case, and it was purely in his capacity as a journalist,
right,
and not as a lawyer. So initially, I think from the report that I read, the assessing individual at the Law Society felt that there was no reasonable prospect that a hearing would go ahead because he was not acting in his capacity as a lawyer. But because of a complaint from somebody from the Human Rights Commission, the complaint's going ahead. So I think it's unfortunate because lawyers are allowed to have other careers, even though if you are still licensed, doesn't mean you should be sanctioned for your journalism or your outspoken political comments.
So now it becomes a little more complicated because he's saying, well, I want to resign, but I'm not going to resign if there's still a complaint pending.
Yes.
So he wants to leave that career unblemished.
Mm-hmm.
Yeah, but I think the deal he was trying to suggest is that by resigning, I'm no longer going to be a practicing, although he's not practicing, I won't be a licensed lawyer, so that should solve the issue. But they don't have to allow that. They can proceed with the hearing regardless of whether he wants to resign or not. And he's said quite clearly that if that's the case, he's not going to resign. He'll, I guess, go ahead with the hearing. But it's a serious question with respect to censorship in some respects. I think if he was saying this somehow in his capacity as a lawyer while involved in some case and saying it publicly, I think that's slightly different than this particular instance. I'm not aware of the exact comments that are made, but I think this is a particular form of censorship that should not be a matter that the Law Society of Alberta would go forward with.
Well, you, for example, are a frequent commentator nationally on some of the biggest media outlets on cases or matters of law. And if they were to say, well, we may not agree with what your opinion is, that would certainly, that's what we're talking about.
Yeah.
You practice law, but you don't make
I'm more
judgments
measured.
on... Well,
I'm
you
more
don't,
measured
but
in
you
my
don't,
comments.
But you don't make judgments about cases that you are actually, representing somebody in.
No, and if it's also before the court, we all have to be careful about,
Absolutely.
How we comment on the cases. But that doesn't mean that there are people out there in the media field who can't make comments, and it happens on a regular basis in Canada and the United States. And if that person happens to be a licensed lawyer, I'm not sure that should be that should be the forum to deal with not agreeing with their opinion. Maybe a lawsuit or something else would be a more appropriate foundation for that.
So is this going to lead the way then, do you think, if they proceed with more censorship with other law societies across the country? Is it something that offends you?
I find this to be censorship of a journalistic opinion. Now, whether we consider him to be a true journalist or not, that's something else, but I find it to be troubling because I think the public has a right to listen to opinions that are expressed by journalists. You don't have to accept them, but I think there has to be discourse and public opinion about whether a Human Rights Commission or a court does something in accord with opinions of others, and I think this could be quite troubling. If he was clearly practicing law, making commentary as a lawyer, as a legal analyst, that would be something different. This is not the case in my opinion.
Okay, let's move on to the Bosma murder trial.
Mm-hmm. Yes. Yeah, creepier and creepier.
So bring us up to date with what's going on with the case of Dylan Millard and Mark Smitch.
So there was some DNA evidence which came out which wasn't able to be tested. And is somewhat linking in the sense that, there's blood in areas where you wouldn't imagine it. But that's not so significant as the OPP officer who specializes in the forensic analysis of computers and electronic devices. So there was an awful lot of material that he went through with respect to both individuals who are charged, which showed that they were, some instance maybe looking or taking pictures of guns and looking around for trucks that were for sale. They had looked at Mr. Bosma's ad a number of times, and there is some communications which were recorded, I think, on an iPad of Mr. Smish, which shows communications in the morning between the two. From what I've heard so far and from what I've read, it's not necessarily the smoking gun, but it's certainly more circumstantial evidence, which is significant. We've also heard now that's come out that the girlfriend of Mr. Smitch is going to testify, and she's represented by counsel, and her evidence will be quite interesting, because she says she had a discussion with her boyfriend that, in fact, he had the gun which was used to kill Mr. Bosma, and that had been buried. A wide search had been conducted, and no gun was retrieved. Whether she's credible or not, that is something to be seen. I think she has charges as well pending, so we'll see what her evidence will be like, the quality of it, and how she'll withstand cross-examination. But again, it's a slow building of circumstantial evidence leading, closer and closer to the implication of both of these individuals.
You mentioned she has charges in this particular...
Yeah, it arises from these set of facts. I'm not sure exactly what they are, but there could be accessory charges, and those will be dealt with at some later point in time. But she is slated to be a witness. I know she has counsel, and that'll be very interesting evidence to listen to and see how it pans out.
Quite a story.
That's all.
Now we have another case here, which is a Winnipeg man convicted of running a prostitution ring involving young teens.
Not unusual. I mean, we've heard of a number of these. There's the human trafficking cases where young ladies are brought in and young girls are brought in from other countries and are forced into the sex trade. This was an individual who seems to be a little off his nut by putting things on YouTube and was representing himself. So the jury came to a conclusion and convicted him of a number of offenses, including prostitution, living off the avails. I think there was a sexual assault charge as well, because there were a number of pictures found on his computers with him in various positions. So he'll be facing a number of years in jail when it comes to sentencing. I'm not sure if there's any appeal that can arise from it. But, I mean, this is an endemic problem that we see across Canada with human trafficking cases. And, they're treated very seriously and prosecuted aggressively.
And, of course, we talked about this earlier this week, and we're so glad that you're here to make a commentary on the conviction of Maria Shepherd, who pleaded guilty 25 years ago to killing her 3-year-old stepdaughter, and that's been overturned because of the testimony of Charles Smith, the pathologist, who was then found to, there are, I don't know how many cases now, he was used as an expert witness serially. He was almost on
He was the witness and treated like the god of pediatric pathology. And I remember I had, sadly, a couple of cases, and he was just so revered that other experts you would go to wouldn't challenge his opinion. And he was completely unchecked in his own analysis. There was no safeguards and checks in place to double-check what he was doing. And he was the linchpin for a number of wrongful convictions, and it only came out years later. So what's important, I think, about this and what to talk about is the power of an expert, a power of expert testimony in a trial, and how it can drive a conviction, even in a case when somebody's innocent. And because you're faced with such overwhelming evidence, in this case, like many others, an accused, a woman who was not responsible for the death, had to plead guilty to a manslaughter charge, receive a jail sentence, and live with that stigma for many years. And if not for the analysis done on his work and the public inquiry, she could very well have been living with that wrongful conviction.
Well, the other thing, too, is at the time, people hear, well, she pled guilty. Well, the fact is, she told police that she pushed the child once. Now, what happened was her wrist, with a watch, hit the back of the little girl's head.
Yes.
And she said she didn't believe that blow could have killed her.
Right.
But she was then, the lawyer consulted an outside expert who agreed with Smith's theory, and so that prompted her to plead guilty to manslaughter. I mean, how horrible.
Right, but this underscores the danger of expert evidence. And yes, this is pathology and there's a science to it, but there's also a fair degree of interpretation, and there must be safeguards in place. But let's roll this out more. There were wrongful convictions that were overturned in sexual assault cases, where DNA evidence was faulty or not examined, or certain biological evidence was not examined. So an individual who was exonerated by the Court of Appeal a number of years ago, who had served a number of years in jail on sexual assault charges, after other evidence was analyzed, was another type of wrongful conviction. So we have to be very careful about the quality of evidence in any case, whether it is a homicide, a sexual assault, a robbery, whatever. We have to be very careful about the quality of evidence that's used to convict people. And more importantly, we have to have careful scrutiny of what is so-called expert evidence, because there's expert evidence in so many forms. And the test for expert evidence, for leaving aside this case that has, real scientific sort of drapings about it, there's other expert evidence where witnesses come forward who are not scientists. They come forward about their own experience, about how people behave in certain cases, about tattoos and what they mean. I mean, we have to be really careful in our justice system about the weight that we attribute to expert evidence, so that it does not lead a jury to convict, because it has such incredible... You have somebody who's nicely dressed up there with all the trappings of an expert. It has incredible power with a jury, and incredible power in this case with convincing an innocent woman to plead guilty.
So you, as a criminal lawyer, and a preeminent one, when you look at the cases like this, would you then, if you were in court defending somebody, would you, in your address to the jury, say, by the way, let's not forget some, you're attaching, this witness has said this, or this expert witness has said this and that and the other thing, but let's not lay down and pay homage here, because other expert witnesses have resulted in wrongful convictions. Would you use that?
I do. In fact, when I do a jury address, I speak about being on guard against wrongful convictions and carefully analyzing the evidence. And often I challenge the evidence, even if it is admissible in law. I have a case coming up now, which we've just set down for trial, where a psychologist is going to be called in a sexual assault case to testify about something in general about how people behave. And the quality of the evidence that I'm looking at, it really doesn't, in my opinion, reach the threshold of expert evidence. So I'm going to challenge it on a voir dire, cross-examine the expert, and then, if admitted, and I'm going to call my own expert and reply, I'm still going to tell the jury to be very careful about accepting this and just use their own good common sense. It is really, it can be very, very dangerous in criminal cases, so you have to be careful.
Well, I mean, at least now that is something that can be used. There's some good that will come out of this.
And
there is.
Do you feel that, on the whole, let's say in the 25 years since Maria Shepard's initial conviction, have we gotten better at it in the justice system in general?
Well, I mean, certainly with testing of biological evidence, the Center for Forensic Science went through a complete overhaul with their procedures and policies, so they are now a fairly preeminent scientific resource for the authorities. We are now in a better place with respect to pathology evidence, where there are safeguards and checks by other pathologists, and I think the public and courts in particular are much more careful about just accepting evidence at its face value without some very strong scrutiny, and judges are very good about that these days. So I think we have made progress, but that doesn't mean this still can't happen, and we must be vigilant about protecting anybody who's accused of an offense, protecting their rights and scrutinizing the evidence very carefully.
Unfortunately, Joseph, we've run out of time. We could still talk about 2 or 3 more cases, but we are just out of time.
Okay.
That is today's Legal Beat, brought to you by Neuberger & Partners, LLP, one of Canada's leading criminal defense law firms, expertly defending clients since 1992. Visit them online at nrlawyers.com.
Click the channel subscribe button for full-length interviews and more from What She Said here on YouTube.